Hello everybody and welcome to History Bite number 51, dated September 23rd, 2020. I'm Walter, your mobile historian and blue-collar scholar. In this History Bite, we discuss a decision of the Supreme Court of the United States, U.S. Term Limits, Inc. versus Thornton, 514 U.S. 779, 1995. U.S. term limits was an important federalism case from the 1990s, largely forgotten today. But the decision tested just how far U.S. states could go in regulating those individuals who represented them in the U.S. Congress. With respect to this case, in 1992, the people of the state of Arkansas overwhelmingly approved what was known as Amendment 73 to the state constitution. Amendment 73 imposed term limits on individuals representing the state of Arkansas in the Congress. It denied ballot access to any federal congressional candidate who had served 3 or more terms in the U.S. House of Representatives or 2 or more terms in the U.S. Senate, both from the state of Arkansas, of course. But you could still be elected, to the House or the Senate from Arkansas as a write-in candidate. So like most laws, there was a loophole. Okay, way to bypass it, go around it, and still be elected, okay? So Amendment 73 obviously took it a step further than the qualifications in the U.S. Constitution in Article 1, which outlines qualifications for members of the U.S. Congress from the states. Lots of people immediately thought that Amendment 73 was unconstitutional because it essentially took it further than what was already prescribed in the U.S. Constitution for congressional candidates, okay? So suit was filed almost immediately against the state, all right, to prevent Amendment 73 from being effective, all right? And those who took suit against Arkansas prevailed in the state courts, and the matter eventually wound up in the Supreme Court of the United States. So the issue presented to the Supreme Court was quite simple. Were U.S. states permitted to impose additional qualifications for members of the U.S. Congress that obviously either exceeded those in the Constitution, in essence? And the court ruled in a very, very tension-filled, in my opinion, 5-4 decision that they could not impose additional qualifications on members of the U.S. Congress other than those that were already laid out for in the U.S. Constitution. Writing for himself and 4 other colleagues, Justice John Paul Stevens held that allowing states to adopt additional qualifications for members of Congress, other than what was already outlined in the Constitution, would create disorder and an unnecessary patchwork of state laws, disrupting the uniformity of national character that the framers sought when it came to creating our federal legislature, okay? Additionally, he contended that selecting members of Congress and choosing how long they will serve was something that was designed to be in the hands of the people, as evidenced by the 17th Amendment, rather further evidenced by the adoption of the 17th Amendment in 1913, which changed the method of electing U.S. senators to being elected from the people, as opposed to by the state legislatures, as it's how it was done before that, okay? Stevens felt that allowing states to do it as they felt, as long as they technically were not undermining the U.S. Constitution, but term limits, in his opinion, were undermining the Constitution, to let the states do what they want here would create a lot of confusion and disorder, essentially. And, obviously, this is not what the framers intended, according to Stevens. That's why they laid out specific qualifications in Article 1 of the Constitution for members of Congress. Okay? The states were not permitted to undermine that or exceed that, essentially, is what the gist of the opinion held. Okay? In writing for the dissenters, Justice Clarence Thomas rebuked Stevens' analysis in holding that the Constitution was entirely silent on that matter. Okay? And it imposed no restrictions on the states adopting additional qualifications on members of Congress being elected from their states. Okay? Essentially, when the Constitution is silent on a subject, traditionally it provides no bar to action by the states, okay, or by the people. All right? And the majority's opinion here was ignoring an important power in his mind that was reserved to the states, technically under the 10th Amendment, as there was no specific power denied to the states in the Constitution that they couldn't add additional qualifications for members of Congress, as long as they weren't undermining those clear qualifications which already existed. Okay? So, the holding of the court, in essence, states cannot adopt additional qualifications for members of Congress being elected from their states. Okay? What exists in the Constitution are the only qualifications permissible for potential members of Congress. States are not allowed to add qualifications, and certainly not allowed to undermine the qualifications which already exist in the Constitution. And that's the gist of U.S. term limits versus Thornton, 1995. Now, my personal take on this case, I do not agree with the majority opinion, but instead agree wholeheartedly with Justice Clarence Thomas's dissent, as the Constitution, beyond question, is entirely silent on this subject. And where the Constitution is silent, it traditionally poses no bar to action by the states or by the people. Okay? So Thomas, to me, is more in touch with history than was the majority opinion by Justice John Paul Stevens, with all due respect. So that's the gist of U.S. term limits versus Thornton. Hope you learned a lot from this case. You know, it's always been an interesting case to me. And I'll add one more thing, that unlike abortion and a lot of other popular issues of the day, this one has produced almost no reaction from the states. The Supreme Court ruled on it, and they all complied. Not always the case, as you know. So thank you again for listening to this History Bite. I appreciate all of you for listening. If you have any questions or controversies, leave them in the comments below. Take care. Stay safe out there, and I'll talk to you at the next one. Peace.